I go to that point?
After the
Justice Alito?
I don't know how much we can infer from the fact that we haven't seen anything like this before and therefore conclude that we're not going to see something in the future. From the time of the impeachment of President Johnson until the impeachment of President Clinton, more than 100 years later, there were no impeachments of presidents. And in fairly short order over the last couple of decades, we've had 3. So I don't know how much you can infer from that.
Certainly, but if this court affirms, this court can write an opinion that emphasizes how extraordinary insurrection against the Constitution is and how rare that is, because it requires an assault not just on the application of law, but on constitutionally mandated functions themselves, like we saw on January 6th, a coordinated attempt to disrupt a function mandated by the 12th Amendment and essential to constitutional transfer.
Well, let me ask you a question about whether the power that you've described as plenary really is plenary. Suppose that the outcome of an election for a president comes down to the vote of a single state, how the electors of the vote of a single state are going to vote. And suppose that candidate A gets a majority of the votes in that state, but the legislature really doesn't like candidate A, thinks candidate A is an insurrectionist, so the legislature then passes a law ordering its electors to vote for the other candidate. Do you think the state has that power?
I think there may be principles that come into play in terms of after the people have voted that the state can't change the rules midstream. I'm not sure because I'm not aware of this court addressing it. And certainly, as
let's change it so that it's not after the election. It's 3 days before the election, based on the fact that the polls in that state look bad. Can they do it?
I think they probably could under this court's decision in Chafalo, where this court emphasized that for much of American history, state legislatures picked their own electors and assigned their own electors themselves. But of course, that would be much more extraordinary than what we have here, which is simple application of normal state ballot access principles to say that we're only going to put on the ballot an individual who is qualified to assume the office.
Could I ask you again the question that Justice Gorsuch asked, and to which you responded by citing the de facto officer doctrine? But suppose we look at that going forward rather than judging the validity of an act committed between the time when a president allegedly engages in an insurrection and the time when the president leaves office. During that interim period, would it be lawful for military commanders and other officers to disobey orders of the president in question?
I'm not sure that anything gives military officers the authority to adjudicate effectively the legality of the presidency.
Justice Alito?
Suppose there's a country that proclaims again and again and again that the United States is its biggest enemy, and suppose that the President of the United States, for diplomatic reasons, think that it's in the best interests of the United States to provide funds or release funds so that they can be used by that country. Could a state determine that that person has given aid and comfort to the enemy and therefore keep that person off the ballot?
No, Your Honor. This court has never interpreted the aid and comfort language, which also is present in the treason clause. But commentators have suggested, it's been rarely applied because treason prosecutions are so rare, but commentators have suggested that, first of all, that aid and comfort really only applies in the context of a declared war, or at least an adversarial relationship where there is, in fact, a war between two countries. And second, the intent standard would do a lot of work there, because under Section 3, whatever the underlying conduct is, engaging in insurrection or aid and comfort has to be done with the intent to further the unlawful purpose of the insurrection or to aid the enemies in their pursuit of war against the United States.
Now, let me come back to the question of what we would do if different states had adjudicated the question of whether former President Trump is an insurrectionist using a different record, different rulings on the admissibility of evidence, perhaps different standards of proof, then what would we do?
Ultimately, this court would, first of all, if there were deficiencies in the record, the court could either refuse to hear the case or it could decide on the basis of deficiencies of the record.
Well, would we have to decide what is the appropriate rule of evidence that should be applied in this case? Would we have to decide what is the appropriate standard of proof? Would we give any deference to these findings by state court judges, some of whom may be elected? Would we have to have our own trial?
No, Your Honor. This Court takes the evidentiary record as it's given, and here we have an evidentiary record that all the parties agree is sufficient for a decision in this case. And then, as I discussed earlier, there's a possibility of a Bose Corp independent review of the facts. But ultimately what we have here is an insurrection that was incited in plain sight.
But you're really not answering my question. It's not helpful if you don't do that. Suppose we have two different records, two different bodies of evidence, two different rulings on questions of admissibility, two different standards of proof, two different sets of fact findings by two different judges, or maybe multiple judges in multiple states. Then what do we do?
Well, first, this Court would set the legal standard, and then it would decide which view of the record was correct, I think, under that. If this Court had two cases,
which view of what record? Which record?
If this Court had two cases before it, and both of the records were sufficient insofar as both sides had the opportunity to present their case and the essential facts in the record that everyone agreed was sufficient for decision, then this Court would have to look at the evidence presented and decide which holding was correct, and then decide that issue for the country. And certainly here, when there is a complete record, lower courts then will be applying that decision, and I think it's unlikely that any court would say, we're going to reach a different decision than the U.S. Supreme Court did, particularly if the court relies on the facts, the indisputable facts of what President Trump said on video and in his Twitter feed, which is really the essence of our case here.
Well, you had an expert. Let's just take that example. Had an expert testify about the meaning of what President Trump said. But do you think it's possible that a different state court would apply Daubert differently and say that this person should not be allowed to express an expert opinion on that question? You think that's beyond the realm of imagination?
Not at all, Your Honor. 2 points on that. Number one, President Trump didn't appeal the admission of that evidence in this case. But number two, the second point is that Professor Simi really, he didn't opine on the meaning of President Trump's words. He opined on the effect that those words had on violent extremists. And the essence of his testimony was built around videotaped statements of President Trump himself, encouraging, inciting, and praising political violence.
I'm not taking a position one way or the other about whether the expert's testimony should have been admitted or anything like that, or the meaning of President Trump's words. I'm just trying to get you to grapple with what some people have seen as the consequences of the argument that you're advancing, which is that there will be conflicts in decisions among the states, that different states will disqualify different candidates. But I'm not getting a whole lot of help from you about how this would not be an unmanageable situation.
If this Court writes an opinion affirming on the basis of the indisputable facts of what President Trump said on January 6th and in the weeks leading up to it, and his virtual confession on Twitter after the fact, then it would be reversible error for any other state to conclude otherwise on that question of federal law. Or at the very least, this Court could address that when those issues come up, but it seems unlikely.
Mr. Clement, can I ask you about the facial nature of this? Because my understanding is that to strike down this statute is facially unconstitutional. We would have to conclude that there's no possible way for this law to govern these entities and their conduct. So first, do I have the standard right?
With all due respect, I don't think so. In the First Amendment context, as my friend was indicating, the question is whether or not the statute has a plainly legitimate sweep. So it's not the Salerno, if there's one little application somewhere, that's enough to save the statute.
But, I mean, whose burden is that? I thought it was your burden to say that this statute, in almost all of its applications, or in most or a substantial number or something, would be unconstitutional in order to get it facially stricken.
So two things, Your Honor. I think our burden would be our burden to say that this statute doesn't have a plainly legitimate sweep. In fact, it is our position, and we did make this argument below and succeeded, that this statute actually has no constitutional application. And part of that is because none of this statute, at least none of the part that's in front of you today, applies unless you are a covered website. And the website...
Wait, I don't understand. I'm sorry. So no application, but we have so many different applications of the law in this situation precisely because it is so broad. So how can you say that?
Because the statute only applies to websites that are a handful of websites that meet the viewership threshold or the total sales threshold. And it's not our only argument, obviously, but one of our arguments is you can't regulate expressive activity in that kind of
and those websites
way.
Does the Florida law cover Gmail?
The Florida law, I think by its terms, could cover Gmail.
All right. So does Gmail have a First Amendment right to delete, let's say, Tucker Carlson's or Rachel Maddow's Gmail accounts if they don't agree with her or his or her viewpoints?
They might be able to do that, Your Honor. I mean, that's obviously not something that has been the square focus of this litigation, but lower courts...
Well, if they don't, then how are we going to judge whether this law satisfies the requirements of either Salerno or overbreadth?
So it's, again, I think it's the plainly legitimate sweep test, which is not synonymous with overbreadth, but in all events, since this statute applies to Gmail, if it applies at all, because it's part of Google, which qualifies over the threshold, and it doesn't apply to competing email services that provide identical services, that alone is enough to make every application of this statute unconstitutional.
Does it apply to... go ahead. Is the situation of people who have possessed bump stocks between the time of the ATF's new rule and the present day, or between the time of the new rule and the Fifth Circuit decision, can they be prosecuted?
I think probably yes, unless they had gotten some judicial relief from the rule. The rule has not been enjoined. It hasn't been vacated writ large. So I think the government has made clear that this is what we think the statute means. I'll say in practice...
Isn't that disturbing? People in the Fifth Circuit who've been possessing firearms since the beginning of 2023, let's say they are aware of the Fifth Circuit's decision that they can be criminally prosecuted for doing something that the Court of Appeals that governs their territory has said is not illegal?
Well, let me give a practical answer and then a doctrinal answer. I think practically I'm not aware of a lot of these prosecutions being brought because we recognize that there is some legal uncertainty. But I think doctrinally that could happen all the time, Justice Alito. Circuits disagree about what a criminal law means, and someone might, in reliance on their circuit precedent, do something that they think is lawful under circuit precedent that other circuits disagree with, that the government disagrees with, and that this court ultimately holds is covered by the statute.
When we speak of the function of an inanimate object, don't we normally look at what that inanimate object does? So why isn't the function of a trigger to release the hammer? Let's look at the M16, the AR-15. Why isn't the function of the trigger to release the hammer from the sear so that the hammer can swing forward and strike? Isn't that the most straightforward interpretation of this?
I don't think so, and I think even if you thought that was true just looking at the text alone, the three indications that we've talked about, the contemporaneous usage by the president of the NRA and others, the application to other kinds of triggers, which everybody agrees are covered but which don't function by moving the hammer, and then also just evasion. I mean, I talked about some of them, but one of the devices that the Fifth Circuit has held is permissible, or I'm sorry, a district court in the Fifth Circuit has held is permissible, and the Fifth Circuit has declined to stay, is something called a forced reset trigger. And with a forced reset trigger, the ATF tested it, zip-tied the trigger back, and the gun shot multiple bullets. What the district court said is that under my friend's interpretation, there are multiple functions of the trigger because the trigger is wiggling back and forth imperceptibly and releasing the hammer separately each time, and so it's not a machine gun. And I think it's just not reasonable to read the statute that opens it up to that sort of evasion, and we're seeing concrete evidence of that evasion in the Fifth Circuit.
Thank you.
Justice Thomas, anything further? Justice Alito?
On the question of the meaning of coercion, I can think of a spectrum. On one end of the spectrum, a government official says, look, suppress this speech, and if you don't do it, I have legal weapons I can use against you, and I'm going to punish you using those. That's very clear coercion. At the other end, the government official who has no authority to do anything for any practical purposes to the entity that the government official is speaking to says, you should do this, it would be a good thing to do, you'd be a good citizen if you did it. And in between, there are a lot of different gradations, particularly when the official who's making this request has that power, and you have to assume that the person or the entity to whom or to which the request is being made knows that, just as I am sure that these insurance companies were well aware of the power of Ms. Vullo. So how do you define when it goes too far along that line?
So I do think that the power of the official over those to whom she is speaking is a relevant factor in the assessment. But the assessment is, at the end of the day, would a reasonable person in this situation feel that the government is coercing it, that it is implying some sort of threat of action against it, of adverse action against it. So the mere fact that someone exercises regulatory power over you, I don't think is sufficient. But when combined with what you have here, explicit requests to punish a group because of its advocacy, and the invocation of the very tools she has to make life miserable for them, you're not managing reputational risk. We might fine you, or you've got these technical insurance infractions. We might go after your partners and require them to never provide you affinity insurance ever again. This is on the first end of the spectrum that you identified, Justice Alito. So I agree there are hard cases in the middle, and that's true with any standard that at the end of the day looks at coercion. In the context of confessions, coerced confessions, there are some hard lines to draw. This one is not.
Okay. The Solicitor General urges us not to consider the enforcement actions against Lloyds, Lockton, and Chubbs, and the consent decrees, and it argues that the district court held that those actions are entitled to absolute prosecutorial immunity, and petitioner has not challenged that holding here. Do you want to comment on that?
Yes, thank you. Respondent never asserted absolute immunity with respect to the Bantam books, the First Amendment claims in this case. Absolute immunity was only asserted with respect to a separate selective enforcement claim. They chose, with respect to the First Amendment claims, to only assert qualified immunity. That's number one. So it was not asserted below. It was not asserted in the Court of Appeals. It was not raised in the bio. It's not appropriate for this court to decide at this stage.
Thank you. General, let me give you a specific example, which picks up but provides a little bit more detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots. And as a result of this, our police officers have to remove them forcibly from the courtroom. And let's say we have to it delays the proceeding for 5 minutes. And I know that experienced advocates like you and Mr. Green are not going to be flustered by that, but, in another case, an advocate might lose his or her train of thought and not provide the best argument. So would that be a violation of 1512C2?
I think it would be difficult for the government to prove that.
Why?
At the outset, we don't think that 1512C2 picks up minimal, de minimis, minor interferences. We think that the term obstruct on its face connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes. Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of
plain
as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is to retard in progress or action by putting obstacles in the way. So it doesn't require obstruction. It requires the causing of delay.
And if this
So again, why wouldn't that fall within? Now, you could say, well, we're not going to prosecute that. And indeed, for all the protests that have occurred in this court, the Justice Department has not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But why isn't that a violation of 1512C2?
We read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well, that's
and
not
the
a
concept
corrupt
of
intent. It's wrongful. Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say that they weren't conscious of the fact that they weren't allowed to make that kind of brief protest in the court. And I think it's in a fundamentally different posture than if they had stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and done so with clear evidence of intent to obstruct.
Absolutely. What happened on January 6th was very, very serious, and I'm not equating this with that. But we need to find out what are the outer reaches of this statute under your interpretation. Let me give you another example. Yesterday, protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco. What if something similar to that happened all around the Capitol, so that all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there? Would that be a violation of this provision?
It sounds to me like that wouldn't satisfy the proceeding element nor the nexus requirement.
Why would it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
Well, if we had clear evidence that the purpose of the protesters who had set up the blockage somewhere, some distance away from the court, was because they had a specific proceeding in mind, maybe you have the proceeding, but still the court has required a nexus, and that's been the requirement in cases like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work, because you have to show that the natural and probable effect of the action is to obstruct. There has to be a relationship in time, causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute 7212, that use this exact same formulation that the court has characterized as an omnibus clause and never suggested could be subject to an evidence gloss. So I don't think that, to the extent you have concerns about those hypotheticals, your question about what would happen in this courtroom could be covered by 1503. And interpreting this statute narrowly isn't going to cure that issue.
Let me give you one more example. An attorney is sanctioned under Rule 11 of the Federal Rules of Civil Procedure by filing pleadings, written motions, or other papers for the purpose of causing unnecessary delay or needlessly increasing the cost of litigation. And in a particular case, the judge imposes Rule 11 sanctions and says, this caused a lot of trouble. I can tell you it caused at least 5 work days for me personally, all of this unnecessary paper. And it delayed the progress of this litigation. So I'm imposing Rule 11 sanctions. Why doesn't that fall within your interpretation of this provision?
Congress created a specific safe harbor in 1515C. It's reprinted at page 17A to the appendix of our brief that specifies that advocacy or legal representation that is conducted as part of a proceeding shouldn't be understood as obstruction. So I think Congress was itself trying to draw some lines around participation in a proceeding on the one hand versus external forces that obstruct the proceeding on the other.
What is your definition of the status of homelessness? Is it the lack of a place to stay indoors on a particular night, or is it something broader than that?
So homelessness.
Does it require more than that?
Right.
homelessness is defined as lacking a fixed, regular, adequate nighttime address. So if you have a home, you have a home. I'm not homeless when I go to Grants Pass because I have a home in D.C. The second part of our class definition focuses on whether the homeless person has access to shelter. That's not because that's part of the status. It's because when someone has access to shelter, then the ordinances aren't punishing them for the status. It's punishing them for the conduct of not going.
Well, I ask the question because if homelessness is defined as simply lacking a place to stay indoors on a particular night, then there is an ironclad connection between the conduct, which is sleeping outside, and the status of homelessness. But if homelessness is defined to require more than that, then my question would be whether someone who is lacking a place to stay on a particular night or for a particular period of time is homeless if the reason why the person finds himself or herself in that status is, for example, the person refuses to take antipsychotic medicine that's been prescribed, or refuses to go to drug rehab, or rehabilitation for alcoholism, or the person has chosen to move from one place where the person might have a shelter or a home where the person could live to another place. What about all of that?
So the status of homelessness is something that only changes once the person has a home. You lose your home, you're homeless. If you have a home again, then you're not in the status anymore. I think what your question gets at is that second piece, which is whether a person has access to shelter. That can change from day to day. And so—
No, that's not really what my question gets at. The question is, you can draw a distinction. Status is different from conduct. But there are some instances of conduct that are closely tied to status, or if homelessness is defined as simply lacking a place to stay on a particular night, they amount to the same thing. The definition of homelessness encompasses the conduct of sleeping outside. So my question is whether this is, what if the person finds that person in a homeless state because of prior life choices or the refusal to make future life choices? That's the question.
Yeah. So our definition of lacking access to shelter is lacking physical or legal access to shelter, and you're looking at the person's situation on that particular night. I think generally we're not doing an inquiry into all of a person's life choices that might have led them to the point where they're homeless and can't find a place to sleep. Robinson certainly didn't do that sort of analysis with respect to addiction, but there could be situations where there is such a tight causal nexus between a choice a person has made and their lack of shelter access that you would say this person has chosen not to take the shelter. And to be very clear, if you decline shelter that is physically and legally available to you, you're not in our class.
Well, see, the problem is that once you move away from the definition that makes the inquiry basically tautological, then you get into the question of assessing the closeness of the connection between the status and the conduct. And you do run into problems with the person who's a kleptomaniac, or a person who suffers from pedophilia. So how do you distinguish that? How does the court assess how close the connection has to be?
So for both of those categories, the status is defined. I don't know if status is the right word there. Being a pedophilia or having pedophilia is defined by the urge that you have, not by your conduct and acting on that urge. So if someone were to act on that urge, and then you had that tight causal nexus and why they didn't have access to shelter, then they would be outside of our claim.
Justice Alito?
Could you explain how your rule would be carried out by police officers on a day-to-day basis? Let's say that there are 500 beds in a particular town, and let's say it's 3 o'clock in the afternoon, 4 o'clock in the afternoon on a winter day. What is an individual police officer supposed to do? The individual police officer would go around and count the number of people who are getting ready to sleep outside. I guess if it's 4 o'clock, you wouldn't get that. Let's say it's 6 o'clock. Count the number of people who are getting ready to sleep outside for the night and then ask each one of them whether you've tried to find a bed at a shelter, whether that person would be willing to go to a shelter if a bed is available, without any conditions, or whether the bed would have to be available on the conditions that the individual wants, like I won't go to a shelter where they won't take my dog or something like that. And just explain how it would work on a daily basis.
Well, first of all, with respect to the individual encounter, I think the way this would work in the real world, I think it's important to understand what happens on the ground in these situations. I think in the circumstances you're talking about, I think what would happen is that the person encountering the homeless person would know whether there is a spot available. I don't think the homeless person would be required to check each day with each shelter if there are multiple shelters. And in larger cities, these initial encounters are not handled by law enforcement. They're typically handled by social services agencies who are in contact with people who are camping and know what their circumstances are, and they are able to say, we know that at such and such shelter there are beds available. Would you be willing to go?
What if there's a question about whether there are indeed enough shelter beds available? Your rule wouldn't apply if there are enough beds available, right? If there are 500 shelter beds and there are only 200 people who are trying to sleep outside, then your rule wouldn't apply.
Right.
So you have to have a comparison of the number of beds available with the number of people who want to sleep outside.
Right, yes.
So that would be the threshold question.
Right. I just want to clarify one point about that. It's not simply a measure of the number of beds against the number of homeless people, such that if there is a deficit, the city can't enforce the law at all. If you have individualized questioning and you know that there are vacancies available, even if not for everybody, but there is a vacancy for the person being interviewed, then yes, that person, if that person is offered and refuses, that person could be prosecuted. Or cited. So
what if the person says, I know there's a bed available at the Gospel Rescue Mission, but they won't take my dog?
Yeah, I don't think the inability to take your dog to the shelter is a sufficient reason. There are shelters in some larger cities that may well take pets. But
I know I could sleep in the home of a family member, but they really hate me and they're really nasty to me. I'm not. These are. I'm just wondering how this is going to be administered on a daily basis.
And I think, with all respect, I think that example is if the family is going to accept them, but that's the question, whether there is a place to sleep. And I don't know that it would very often come down to that family hates me. On the other hand, if it's a woman who left domestic abuse, she couldn't be expected to go back to her home, or maybe her relative's home, or his relative's home, or something. So there's a lot of common sense. And again, the first encounter that a police officer or somebody else has with a homeless person is very unlikely to be a situation in which the person would be issued a citation.
You mentioned just a couple of things that I wanted to follow up on. Does it matter whether the person grew up in the town or not? Suppose that they go to okay, that's irrelevant. So if they go up to some police officer or social services in San Diego goes up to somebody and says, where are you from? Oh, I'm from Fargo, but if I have to sleep outside, I sure would rather do it here than in Fargo. That doesn't matter.
No, and I think not because of any Eighth Amendment rule we're talking about, but under this court's decisions in Edwards and Sines, the Privileges and Immunities Clause or the Commerce Clause or the various right to travel provisions would prohibit attaching that sort of limitation to a newcomer. But I would, as I mentioned, the majority of people are from
where I used to live in New Jersey, there are a lot of really small municipalities. I think over 500 municipalities in the state. I could go for a 20-minute walk in the evening and be in 3 or 4 different municipalities. So to get back to the Chief Justice's question, if there aren't enough beds available in West Caldwell, does it matter? Is it West Caldwell's out of luck, even though there are a lot of beds available in Caldwell, which is, you know, a couple, less than a mile away?
Yeah, I think the way you're describing it, it might be fair to say that set of small and closely knit communities would be one community, and the person wouldn't basically be banished from where he lived or where he grew up by saying, you know, if there's a shelter in this other location, then you could be expected to go there.
There's some tiny municipalities. What if a municipality doesn't have a park? So if somebody is going to sleep outside, the only place where that person can sleep is going to have to be on the street.
Why?
What does a time, place, or manner restriction work there?
I mean, certainly not on the street, and I mean, because of safety, traffic, et cetera. I mean, there are common sense accommodations, and I think even in the smallest town, there are probably locations where a person could sleep. All
right, thank you. Mr. Rayner, I'm a little curious about your statistical argument. So let's say that that your office files a motion for emergency relief, and you want to try to convince us that there's a probability that we're going to grant certiorari. If you, in making that argument, you say, look, we're very selective in the Solicitor General's office about when we're going to petition for certiorari. We get lots of requests from the litigating divisions to file cert petitions, and we go along with that in a tiny minority of the cases. And we have quite a good record of success when we do petition for cert. Is that something we should consider in that context?
Justice Alito, I don't think there's any bar to the court considering it. And just, if I may.
Seriously?
I certainly don't think there's a bar. This is an equitable analysis. But I think the context here is different in that Congress—
Yeah, I think you're going to have to tell me why it's different.
The reason is that Congress has set up a scheme where the agency can seek 10J relief to protect its own adjudicative authority. And as Justice Jackson mentioned, the history here is that initially there was pretty widespread judicial intrusion into labor disputes. And in 1932, Congress cut that off and said we're not going to allow district courts to intervene. And in 1935, it centralized adjudication of disputes in the board. In 1947, it decided it had to walk back its restriction a little bit, and so it allowed Section 10J relief. But it didn't allow Section 10J relief for district courts to engage in a wide-ranging and intrusive involvement in labor disputes. It allowed courts to come in basically as ancillary to the agency proceedings and protect the integrity of those proceedings. And in that context, I do think it is relevant that the board is selective about the petitions that it files.
Judge Rubin, do you really, I mean, the presidents have to make a lot of tough decisions about enforcing the law, and they have to make decisions about questions that are unsettled, and they have to make decisions based on the information that's available. Do you really, did I understand you to say, well, you know, if he makes a mistake, he makes a mistake, he's subject to the criminal laws just like anybody else? You don't think he's in a peculiarly precarious position?
He's in a special position for a number of reasons. One is that he has access to legal advice about everything that he does. He's under a constitutional obligation he's supposed to be faithful to the laws of the United States and the Constitution of the United States. And making a mistake is not what lands you in a criminal prosecution. There's been some talk about the statutes that are issued in this case. I think they are fairly described as Malaman say statutes, engaging in conspiracies to defraud the United States with respect to one of the most important functions, namely the certification of the next president.
Well, I don't want to dispute the particular application of 371, conspiracy to defraud the United States, to the particular facts here, but would you not agree that that is a peculiarly open-ended statutory prohibition, in that fraud under that provision, unlike under most other fraud provisions, doesn't require any impairment of a property interest?
It's designed to protect the functions of the United States government, and it's difficult to think of a more critical function than the certification of who won the election.
Yeah, I'm not, as I said, I'm not discussing the particular facts of this case, but it applies to any fraud that interferes seriously with any government operation, right?
So what the government needs to show is an intent to impede, interfere, or defeat a lawful government function by deception, and it has to be done with scienter. These are not the kinds of activities that I think any of us would think a president needs to engage in order to fulfill his Article 2 duties, and particularly in a case like this one. I want to pick up on something that the court said earlier about the distinction between a public official acting to achieve public ends and a public official acting to achieve private ends. As applied to this case, the president has no functions with respect to the certification of the winner of the presidential election. It seems likely that the framers designed the Constitution that way because at the time of the founding, presidents had no two-term limit. They could run again and again, and were expected potentially to want to do that. So the potential for self-interest would explain why the states conduct the elections. They send electors to certify who won those elections and to provide votes, and then Congress in a extraordinary joint session certifies the vote. And the president doesn't have an official role in that proceeding. So it's difficult for me to understand how there could be a serious constitutional question about saying you can't use fraud to defeat that function. You can't obstruct it through deception. You can't deprive millions of voters of their right to have their vote counted for the candidate who they chose.
Thank you, counsel. Justice Thomas? Justice Alito?
Could we just briefly review the layers of protection that you think exists? And I'm going to start with what the D.C. Circuit said. So the first layer of protection is that attorneys general and other Justice Department attorneys can be trusted to act in a professional and ethical manner, right?
Yes.
How robust is that protection? I mean, most of the vast majority of attorneys general and Justice Department attorneys, and we both served in the Justice Department for a long time, are honorable people, and they take their professional ethical responsibilities seriously. But there have been exceptions, right, both among attorneys general and among federal prosecutors.
There have been rare exceptions, Justice Alito, but when we're talking about layers of protection, I do think this is the starting point. And if the court has concerns about the robustness of it, I would suggest looking at the charges in this case.
Well, I want to talk about this in the abstract, because what is before us, of course, does involve this particular case, which is immensely important. But whatever we decide is going to apply to all future presidents. So as for attorneys general, there have been two who were convicted of criminal offenses while in office. There were others. A. Mitchell Palmer's one that comes to mind, who is widely regarded as having abused the power of his office. Would you agree with that?
I would, but they are two officials in a long line of attorneys generals who did not, and in departments of justice that are staffed by multiple people who do adhere to their office. And Justice Alito, if I could the point that I wanted to make about this case does go to the general proposition. The allegations about the misuse of the Department of Justice to perpetuate election fraud show exactly how the Department of Justice functions in the way that it is supposed to. Petitioner is alleged to have tried to get the Department of Justice to send fraudulent letters to the states to get them to reverse electoral results.
Yeah, I understand that, Mr. Dreeben, but as I said, this case will have effects that go far beyond this particular prosecution. So moving on to the second level of protection that the D.C. Circuit cited, federal grand juries will shield former presidents from unwarranted indictments. How much protection is that?
Well, it affords two levels of protection. One is the probable cause finding requires evidence. I think some of the fears about groundless prosecutions aren't supported by evidence, and they're not going to get out of the starting gate.
I mean, there's the old saw about indicting a ham sandwich.
Yes, but I think Justice
you had a lot of experience in the Justice Department. You come across a lot of cases where the U.S. attorney or another federal prosecutor really wanted to indict a case and the grand jury refused to do so.
There are such cases. Yes. But I think that the other
Every
level
once in a while there's an eclipse, too.
Well, I think that that's for the most reason is prosecutors have no incentive to bring a case to a grand jury and secure an indictment when they don't have evidence to prove guilt beyond a reasonable doubt. It's self-defeating.
All right. Then the third level is that former presidents enjoy all the protections afforded all criminal defendants, right? And we've discussed that. And that may be true at the end of the day, but a lot can happen between the time when an indictment is returned and the time when the former president finally gets a vindication, perhaps on appeal. Isn't that correct?
It is correct, Justice Alito, but I think that we should also consider the history of this country. As members of the court have observed, it's baked into the Constitution that any president knows that they are exposed to potential criminal prosecution. My friend says after impeachment and conviction, we don't read the impeachment judgment clause that way, but it's common ground that all former presidents have known that they could be indicted and convicted. And Watergate cemented that understanding. The Watergate smoking gun tape involved President Nixon and H.R. Haldeman talking about and then deciding to use the CIA to give a bogus story to the FBI to shut down a criminal investigation.
I mean, Mr. Sauer and others have identified events in the past where presidents have engaged in conduct that might have been charged as a federal crime, and you say, well, no, that's not really true. This is page 42 of your brief. So what about President Franklin D. Roosevelt's decision to intern Japanese Americans during World War II? Couldn't that have been charged under 18 U.S.C. 241, conspiracy against civil rights?
Today, yes, given this court's decision in Trump versus United States, in which Trump versus Hawaii, where the court said Korematsu is overruled. I mean, President Roosevelt made that decision with the advice of his Attorney General. That's a layer of safeguard.
Is that really true? I thought Attorney General Biddle thought that there was really no threat of sabotage, as did J. Edgar Hoover.
So I think that there is a lot of historical controversy, but it underscores that occurred during wartime. It implicates potential commander-in-chief concerns about the exigencies of national defense that might provide an as-applied Article II challenge at the time. I'm not suggesting today, but the idea that a decision that was made and ultimately endorsed by this court, perhaps wrongly, in the Korematsu case, would support criminal prosecution under 241, which requires under United States versus Lanier that the right have been made specific so that there is notice to the president. I don't think that would have been satisfied.
All right. Well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the Attorney General that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our brief, our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
On the question of whether a president has the authority to pardon himself, which came up earlier in the argument, what's the answer to that question?
I don't believe the Department of Justice has taken a position. The only authority that I'm aware of is a member of the Office of Legal Counsel wrote on a memorandum that there is no self-pardon authority. As far as I know, the Department has not addressed it further, and of course this court had not addressed it either.
Well, when you addressed that question before us, are you speaking in your capacity solely as a member of the special counsel's team, or are you speaking on behalf of the Justice Department, which has special institutional responsibilities?
I am speaking on behalf of the Justice Department, representing the United States.
Now, don't you think we need to know the answer to at least to the Justice Department's position on that issue in order to decide this case? Because if a president has the authority to pardon himself before leaving office, and the D.C. Circuit is right that there is no immunity from prosecution, won't the predictable result be that presidents on the last couple of days of office are going to pardon themselves from anything that they might have been conceivably charged with committing?
I really doubt that, Justice Alito. I mean, it sort of presupposes a regime that we have never had except for President Nixon and, as alleged in the indictment here, presidents who are conscious of having engaged in wrongdoing and seeking to shield themselves. I think the political consequences of a president who asserted a right of self-pardon that has never been recognized, that seems to contradict a bedrock principle of our law that no person shall be the judge in their own case. Those are adequate deterrents, I think, so that this kind of dystopian regime is not going to evolve.
All right, let me end with just a question about what is required for the functioning of a stable democratic society, which is something that we all want. I'm sure you would agree with me that a stable democratic society requires that a candidate who loses an election, even a close one, even a hotly contested one, leave office peacefully if that candidate is the incumbent.
Of course.
All right. Now, if an incumbent who loses a very close, hotly contested election knows that a real possibility after leaving office is not that the president is going to be able to go off into a peaceful retirement, but that the president may be criminally prosecuted by a bitter political opponent, will that not lead us into a cycle that destabilizes the functioning of our country as a democracy? And we can look around the world and find countries where we have seen this process, where the loser gets thrown in jail.
So I think it's exactly the opposite, Justice Alito. There are lawful mechanisms to contest the results in an election. And outside the record, but I think of public knowledge, petitioner and his allies filed dozens of electoral challenges, and my understanding is lost all but one that was not outcome determinative in any respect. There were judges that said in order to sustain substantial claims of fraud that would overturn an election result that's certified by a state, you need evidence, you need proof. And none of those things were manifested. So there is an appropriate way to challenge things through the courts with evidence. If you lose, you accept the results. That has been the nation's experience. I think the court is well familiar with that.
Thank you.
Justice